Guns and alcohol don't mix. That's exactly why Florida Statutes Chapter 790 mentions alcohol 33 times. That seems like something we should investigate. Even if you don't drink alcohol, this video still applies to you, because at a bare minimum, you have a responsibility as a gun owner to be educated on Florida gun laws. In this video, we're discussing alcohol and guns. Let's get into it. If you want to jump to the meat and potatoes, you can skip ahead. But I want to explain where I'm getting and how I'm getting the information. So I'm opening up a web browser, I'm going to Google, and I'm typing in Florida State Statutes. I'm getting to this page. If you scroll down here to the crimes section, you'll see 775 through 896. We're looking for Chapter 790. Weapons and Firearms, Chapter 790. Here's the trick. Click on this View Entire Chapter. What that does, if you change back and forth, you'll see the hyperlinks go away. With this one, you only get the table of contents, and as you click, you can open up. If you click here, you get every single statute going all the way down, so you can look at them all. Now, if we hit Control F, it'll bring up the search box. We can type alcohol into that search box, and that's going to show us how many times alcohol is mentioned, and we use those up and down keys to cycle through. Now you can follow along. So I've grouped these relevant mentions of alcohol into 3 different categories: alcohol abuser limitations, restrictions on concealed carry permit holders, and GUI, gunning under the influence. Alcohol abuse is a problem for people trying to get their concealed carry permits. Florida is a shall issue state, but it shall issue unless. Let's look at the language. The Department of Agriculture and Consumer Services shall issue a license if the applicant, so we have A, B, C, D, E, and I want to focus on the F, does not chronically and habitually use alcoholic beverages or other substances to the extent that his or her normal faculties are impaired. So how do we measure that? Well, if we continue reading the statute, it gives us some pretty clear instructions. It shall be presumed that an applicant chronically and habitually uses alcoholic beverages or other substances to the extent that his normal faculties are impaired if the applicant has been convicted of gunning under the influence or been deemed a habitual offender under 856.011, drunken disorderly type charges, or has 2 or more convictions under 316.193, DUI, or similar laws of other states within a 3-year period immediately preceding the date on which the application is submitted. So what does this mean? If you get back-to-back alcohol-related events, you can't get a concealed carry permit, or your concealed carry permit will be suspended from the date of those arrests or convictions. I'm not sure what they're going to go by. We see similar language about chronic alcohol abuse in Florida Statute 790.25. If you recall, this is the statute that gives us all the exceptions to carry without a concealed carry permit. So it's a big one. Done a couple of videos on this statute already. If you're interested in watching, I'll put a link to those down in the description or maybe up there. So what's the takeaway? If you get back-to-back alcohol-related charges, you're going to lose your concealed carry permit, and you're essentially going to lose your right to carry a firearm and possess a firearm in Florida for the 3 years immediately following that incident. They'll probably suspend your right pending the conviction, and once your conviction, it'll be for 3 years from that date. Not really in the same group, but since it's affecting a concealed carry permit on possession, I also want to talk about RPOs, risk protection orders. Risk protection orders, kind of like an injunction for firearms. Police get called out to your house for some reason or another. They believe you to be a threat with firearms, so they report that to the judge. The judge then has a hearing, and if they prove by clear and convincing evidence that you're a threat because you're firearms, you have to turn in all of your guns. Scary situation. Got one right now, it's not right. In determining if they're going to grant or deny the RPO, the judge is going to look at the enumerated factors in the statute. One of the factors the judge is going to look at to form the basis of their decision is 790.401, subsection 12. Corroborated evidence of abuse of controlled substances or alcohol by the respondent. That's just one of the factors the judge is going to look at to determine whether they should take away your guns. Bottom line, guns and alcohol don't mix. Before we move on to alcohol-based restrictions on concealed carry permit holders, I want to remind you, the backside of this YouTube channel is a full-service law firm. Keep us in mind if you or someone you know is looking for a lawyer in Florida. A veteran-owned firm proudly serving we the people in Florida. The second category of alcohol-based restrictions that we're going to discuss is those restrictions placed on concealed carry permit holders. The statute places 15 enumerated limitations on where you can't go carrying your firearm, open or concealed. If we look to subsection 12 on that list, we'll see the mention of alcohol. Any portion of establishment licensed to dispense alcohol for consumption on the premises. Which portion of the establishment is primarily devoted to such purpose? What does that mean? You can go in the restaurant, just don't go into the bar area of the restaurant. Walk around. Finally, we get to my favorite, gunning under the influence. 790.151, use of a firearm while under the influence of alcohol or controlled substances. Let's read that statute. Starting with the portion that mentions alcohol, it is unlawful and punishable as provided in subsection 4 for any person who is under the influence of alcoholic beverages, any controlled substance set forth in 877.111, that's inhalants, or any substance controlled under Chapter 893, that's like every other drug you can think of, from pills like Oxycontin all the way up to cocaine. Any controlled or illegal substance. Let's get back into it. It is unlawful to provide subsection 4 for any person who is under the influence of alcohol or drugs, when affected to the extent that his normal faculties are impaired, to use a firearm in this state. What does use a firearm mean? Let's look up to subsection 1. As used in 790.151 through 790.157, to use a firearm means to discharge a firearm or to have a firearm readily accessible for immediate discharge. For the purposes of this section, readily accessible for immediate discharge means loaded and in a person's hand. So GUI, gun has to be loaded and in your hand. You don't have to be actually pulling the trigger. How do they determine if you're drunk? When it comes to GUI testing, it's very similar to DUI testing. The police officer can request a breath, blood, or urine test depending on the circumstances, and you generally have the right to refuse unless it's death or serious bodily injury, but there's an adverse consequence if you do refuse. We'll talk about that in a minute. The breath test must be incidental to lawful arrest, meaning you have to already be arrested before they request the breath test from you. That breath test is only determining the presence of alcohol in your system. They can also request a urine test. That urine test will be looking for the presence of chemical or controlled substances in your system. If they find a chemical or controlled substance in your system, that doesn't necessarily mean you're impaired, but that's substantial evidence towards showing impairment. With GUI, a blood test only comes into the equation if there's death or serious bodily injury. And if they have probable cause to get the blood, they can take it from you. You're not going to have a right to refuse. Let's look at the statute that covers the refusal aspect so you can understand the adverse consequence. The refusal to submit to a chemical or physical test of your breath or urine upon the request of a law enforcement officer, as provided in this section, shall be admissible into evidence in any criminal proceeding. What does that mean? The state attorney, when they prosecute you, they'll be able to say, the reason you refused to take the breath or urine test is because that you knew you were guilty and you were afraid of the results. That's called consciousness of guilt. And as long as there is an adverse consequence and you're informed of that adverse consequence on the front end, they can use it against you on the back end. So what's the legal limit with GUI? It's 0.10, but it's a little bit more complicated than that because you've got to look at the different presumptions of impairment that are given to us by the statute. Depending on the results of your breath or blood test, those are the only two that check alcohol, that will depend on what the jury is instructed with regards to whether you're sober or impaired. If your breath test results are 0.05 or lower, the jury will be instructed that you were sober. If your breath test results are greater than 0.05, but less than 0.10, the jury will be instructed there's no presumption. We don't know whether he's sober or drunk. That's for you to determine, ladies and gentlemen of the jury. If your breath test result is 0.10 or greater, the jury will be instructed to presume that you were impaired. Of course, I'm not sure how much I trust these breath test machines. The ones we're using in Florida are from 2006. What technology do you have from 2006 still in your household? One of my clients got kicked out of a first-time DUI offender program because the alcohol device he had to blow into in his car, the interlock device, it malfunctioned and he blew a .4 after eating a honey bun. That flagged him. They didn't believe that he was drunk on a honey bun. He got kicked out of the program. Had to beat the DUI another way. If you want to check out that video, put a link to it right here. If you like the format of this video, I did the same thing with the word misdemeanor in place of the word alcohol. Check that out. Hit it hard.